and 20 May, and 20 May and 27 June. I've asked them to please do that for us.
Why 20 May?
So for the date of the authorized...
30th May.
30th of May, yes.
Now, I'm just interested from the 30th of May,
Yes,
because we do have the docket 542 of 6, 2025. And I'm saying, on my reading of that docket, I can't find any document relating to investigations post the 30th of May.
I take your word for it.
Well, that's my reading of it, and I accept that I may very well be wrong. We know that that docket is numbered 542/6/2025. And we know that from the cover sheet of Mr. Adams's A1 statement of 6th of January. Would you like us to cast our eye there? That would be...
Are we in file 3?
File 3, page 68. File 3, page 681. Now, if we look at that, we see at the top, it's got a cast number there of 542/06. And I checked with Colonel Padiache, and I think many other police officers that have appeared. I'm reliably informed that the middle number 06 relates to the month in which the case was opened.
That is correct.
So I take it the case was opened in June 2025.
Yes, the docket would have been registered June 2025.
And that is a day after you authorized an investigation, at the earliest, the 1st of June. It doesn't state, it doesn't give us the actual date, but best case scenario is that it's the 1st of June 2025 when a docket is opened.
I take that.
And your authorization to investigate is the 30th of May.
Correct.
So they are already deciding to open a criminal case before proper investigations in terms of Section 28(1). Do you see that? Could have been later in the month of June.
But I do see it's in the month of June.
It's in the month of June.
Yes, ma'am.
And remember, we are chasing the 26th of June, which is the arrest date. And we're trying to understand what happened when, post the 30th of May. Staying on that page, at the bottom of that page is a date. 2025-0106, bottom left corner.
I see that.
Now, Colonel Padiache explained that this was a preamble, this preamble to the statement and the statement were obtained on the 6th of January 2025.
Okay.
That's his explanation, because I couldn't understand why the docket has got a June date, as we have determined, but the statement seems to be taken in January. He had an explanation for that they open the docket, or they take the statement in terms of this document and will subsequently open an official criminal docket later. But that's the explanation as I understood it. And I accept it. I've got nothing to countenance it. So my issue really is, on the 6th of June 2025, already we are into criminal investigation mode. And this is very early during what ought to have been the 2813 preliminary investigation process to help you determine whether to institute a formal investigation in terms of Section 28(1)A. Do you accept
I'm
that?
with you. I accept it.
And that is where then my challenge lies with this 2813 preliminary investigation and the authorization for the actual investigation. And I suggest that, I'll say the investigators in this case, abuse the Section 2813 preliminary investigation to conduct a full-blown investigation before you so authorize them. They've gone so far as to obtain documents from SAPS to prepare an A1 statement in January.
As I indicated earlier, Council, the 2813, while it is a preliminary investigation, does allow you to subpoena documents. It does allow you to engage with witnesses, and it does allow you to do some form of investigation.
Yes.
Yes.
But at this point, while they are doing that, remember we are trying to show up the Section 27 affidavit. SAPS shouldn't be involved. This is now an IDAC process. You approach the referee to perhaps substantiate if that's what's required. Why is SAPS getting involved at this juncture when you are still trying to address the shortcomings in the Section 27 affidavit?
The shortcomings, as I understand it, can only be addressed by us obtaining the necessary documentation to either support or to dispute the claims made by Mr. Adams. It is, as he said, the Section 27 doesn't have supporting documentation.
Yes.
He makes his averments. In order to determine whether or not these become a reasonable suspicion, we need to rely on the allegations he's making, and where would we find the evidence of those allegations?
Yes.
And it is for that reason, Council, that one is able to subpoena documents. And it is so that the documents sought were invariably at SAPS.
No, this document wasn't at SAPS. It was created, it was commissioned by Chief Perumal on the 6th of January.
I'm saying the documents that we would seek in order to support.
Oh.
Yes, sorry.
No, you are ahead of
Sorry.
me. I'm still on this statement.
My
Why
apologies.
is SAPS involved in this statement, which is seeking to obtain clarification on matters raised in the Section 27 referral? Why is it being registered at SAPS already when you have not authorized an investigation?
I think
Why
I'm a
is
bit-
IDAC at Brooklyn Police Station opening a case in January 2025?
If I look at the CAS number, Commissioner Khumalo, 542 of 6/2025 is a CAS being opened in June 2025. It is not January of 2025. That's how the CAS number reads. I understand the conundrum then of what is this date here at the bottom that shows a 6 January.
And also look at the name of the station. Don't just look at the date. Look at the
Correct.
name of the station and the form itself. That's a SAPS form. That's
That is-
not an inquiry from IDAC.
No. So when you register a docket, we register it on the SAPS CAS system, and we have to fulfill the requirements of the CAS system, which is to fill out that form. That's the only way I understand you are able to.
That's exactly the question. Why are you registering a docket on the 6th of January 2025 when you are still at the preliminary investigation stage?
I understand your question. I'm begging to differ only because of the CAS number. The CAS number determines, and I'm not trying to be controversial, the CAS number has always been what determines when the case is registered on CAS. So 542 of 6/2025 says that a case was registered at Brooklyn in the month of June 2025. I sit with the same conundrum as all of you do. What is this 6 January 2025? If we're talking about when was the docket registered, it would work on the CARES number. That is my understanding of it, and that is how it has always worked.
Or it means the docket was registered without a case number, and a case number was added later on. Because looking at these two documents together, the cover sheet which says preamble to the statement on 681, and then the particulars of the offense, that's the affidavit, that's also January 2025. They go together. And all of that would have been done in January 2025. Yes, the case number could have been added later in June, but the substance of the question, when it is still at the preliminary investigation stage. So the substance of the question does not change.
And I understand, and I cannot answer why that happened. It shouldn't happen. It should have been when the CARES number was registered. So what I'm trying to get to, Commissioner, is the SAPS, CARES, and any involvement within the CARES system ought to have been in the month of June 2025, not this date of January. I can't explain the date of January.
Because my expectation would have been that you would have an IPID inquiry number, and you would start with that and only get to the SAPS documents in June.
That is correct.
Thank you, Commissioner. Then just to
Sorry,
complete
can I
yes.
just say that my difficulty with how you explain that a full-blown, what turns out to be a full-blown investigation happens on the back of a decision for a preliminary investigation. My difficulty with that is that full-blown investigation is used to show up an incompetent referral, Section 27, if that's what happened. Because what you had is, you had this wholly inadequate Section 27 affidavit, which on its terms does not make a case that triggers your jurisdiction. You then authorize, as you say you're entitled to do, or you have the power to do, you then authorize a preliminary investigation. And that's where you collect all of this evidence. But you use that to show up a poor referral. So again, that's not the purpose of your Section 2813 preliminary investigation. It's not to assist what should have been kicked out or not accepted by you because it didn't trigger your jurisdiction. It's not to use that process, because if that's what you are doing, then you are using your Section 2813 process for an unintended purpose. Its purpose is not to fix Mr. Adams's poor Section 27.
Correct.
It cannot be. So if your explanation is correct, that's exactly what happened, then we are again in that territory where, in fact, the Section 2813 was used as a pretext to make up a case that Mr. Adams should have pleaded or should have stated in his founding affidavit, and so your people would have acted improperly. They did that which the law doesn't allow to use that process for, which is the point that Ms. Sello was making, that you authorize a preliminary investigation, but that preliminary investigation, in fact, is used to conduct a full-blown investigation. Your explanation of it proves exactly that they use the pretext of your authorization to assist, make a case that places Mr. Adams's complaint into your jurisdiction when, in fact, from the get-go, it didn't fall within your jurisdiction, at least not in Section 27. Do you accept that, if that's what happened?
I accept that.
Okay, thank you.
Thank you, Commissioners. You recall Commissioner Khumalo referred you to the national instruction. I think it's 11 of 2017. Did I understand you to suggest that you were not aware of it? Or Perhaps I misheard.
I did indicate that I hadn't seen the instruction.
Okay.
Yes.
Can we go to file 8? And in particular, to page 3255. For the record, that's CJC 389. 3255. That should be your, what you call your prosecution note addressed to the
DPP.
to the DPP. If we go to 3257, I see at paragraphs 9 and 10, is that not the instruction note that you referenced there? The same instruction note that Commissioner Khumalo referred you to?
That is correct.
So you do know that instruction note?
I didn't see the instruction. I know of this instruction because I got this from the briefing from the team in order to prepare this memorandum.
No, please say that again.
So when I prepared the prosecution memo, it is as a result of a briefing I get from the team. So the charges against the suspects were presented to me by the team. And so part of the charges and part of the case is as a result of the feedback I got from the team. So I would have got from the prosecution a memo, a draft memo, upon which I look at it and then compile my referral to the DPP. But I didn't see the actual instruction as Commissioner Khumalo had shown it to me today. I didn't look at that instruction.
So the upshot of what you are saying is that in your prosecution memo, you referred to documents you had not seen.
I did not see.
Briefing. I'm saying the long and short of it is that in this memo, you referred to documents you had not seen.
Correct, sir.
So you did not even know that the section 9 you are quoting, in fact, says what you say in your memo. Because if you had not seen it, you could not satisfy yourself that it says what you have quoted in paragraph 11.
Section 7. Yes, that's correct. It would have been as a result of the briefing, not of me seeing the
Yes.
document.
So you did not satisfy yourself that what you are quoting in your paragraph 11 is in fact what the instruction says.
No, I relied on my prosecuting team and my investigators.
And then you proceed at paragraph 12 to state, same document, evidence collected proves that accused 1 to 6 contravene the provisions of the above quoted section to benefit accused 7 without just or reasonable cause.
Yes. And that I would have got from the briefing. It's a briefing that they would have given me and indicated, Chair and Commissioners, how each one is allegedly implicated.
What if they are wrong? You are triggering a prosecution. What if they are wholly wrong? Your investigators and whoever it is you rely on.
My prosecutors and investigators.
What if they are wholly wrong? Because nowhere in this document do you say, I come to understand or I'm made to understand. You're making definitive assertions here, suggesting that you are familiar with the prescripts, you are familiar with the evidence that has been collected, and you confirm that accused 1 to 6 have contravened the prescript. How is that not misleading, perhaps, to the DPP?
No, because I did get a briefing and I have no reason to believe that the prosecutors would have briefed me incorrectly.
But you are making assertions to the DPP on matters you know nothing about.
No, I
and
know.
that's by your hand.
Sorry, I interrupted
Sorry,
you.
I was saying, and this is by your hand. So the DPP reads that as she should to understand that the head of IDAC has satisfied herself, because that's what triggers her response at 3255.
Correct, and I'm saying that I satisfied myself from the briefing that I received from my team.
Okay, now, I would like us to turn to your statement, your October 25 statement.